Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Torpy. To my left is Judge Evander. We have both criminal and civil cases on the docket today. 15 minutes per side on the criminal case, 20 minutes per side on the civil case. We have an add-on case. There'll be a change of panel after the third case, so we'll take a short break for that. The appellant can reserve as much time for rebuttal as they'd like. I'll try and help you keep track of that if you choose to do that. First case on the docket is Leon versus State.
May it please the Court, Michael Lufferman on behalf of the appellant Maxwell Leon. I'd like to reserve 5 minutes of my time for a rebuttal.
All right, when the yellow light comes on, you'll be into your rebuttal time.
Thank you, Your Honor. There are 5 claims addressed in the briefs. The State has conceded error regarding the 5th claim, and I appreciate their candor in that regard. I'll rely upon my briefs for the arguments for all of the claims, but let me begin this morning by focusing on claims 3 and 4, and I'll start with claim 3. Claim 3 concerns the first count in the amended information, a count of digital capital sexual battery. And as this court made clear in the Lakey case, in order for a defendant to be convicted of digital capital sexual battery, the state must prove penetration. The union alternative is not sufficient. And that's because a finger is considered an object. And in order to have capital sexual battery based on an object, there must only be penetration. Union is not sufficient. Now, in this case, the court gave an erroneous jury instruction. I don't think there's any dispute about that. The court told the jury that they could convict my client based on either the penetration or the union alternative. However, defense counsel below failed to object, so I've argued in my briefs that the issue is fundamental error, and I've relied upon this court's Lakey opinion, which I submit is in the same procedural posture. Now, in the answer brief, the state argues that this error was not fundamental because the prosecutor did not focus on the error during closing argument. I respectfully disagree. I'd refer the court to page 526 of the trial transcripts, and that's the prosecutor's closing argument in this case. And starting on line 7, the prosecutor stated, and I quote, "Maxwell Leon committed an act upon the alleged victim in which the finger of Maxwell Leon penetrated or had union with the vagina of the alleged victim, 6 years old." So the prosecutor, during closing argument, specifically repeated the improper instruction that the judge gave in this case. And if that's one of the bases that the courts that have said that this is not fundamental error have relied upon, is that there's no mention of the improper instruction during closing argument, certainly that's not the case here. It was specifically repeated by the prosecutor. I've also argued that the evidence in this case is sufficiently ambiguous to meet the fundamental error standard. In the Lakey case, this court quoted from the 4th DCA's opinion in Gill. And I'll do the same right now for the purpose of this argument. In Gill, the 4th DCA said, "The young victim's testimony indicated the penetration occurred. However, a portion of that testimony was sufficiently ambiguous to raise a question for the jury as to whether in fact there had been penetration. There was no independent evidence of penetration." If you looked at the alleged victim's testimony in this case, and I'm referring to page 203, the alleged victim said that my client allegedly would, quote, "feel up on it, like in between the lips." And then the prosecutor asked, "What do you mean by feel on it?" And the answer was, "rub it." I submit that that, just as in Gill, is sufficiently ambiguous. There's no independent evidence of penetration, and her language, rubbing on it, is sufficiently ambiguous that it could be union or penetration. And I'll note that in the Lakey case, where this court granted relief and found fundamental error, the allegation in that case was also that the defendant allegedly, quote, rubbed the victim's genitals, just like she testified in this case. The 3 cases that the state relies upon to say that it's not fundamental error are all distinguishable from this case. The Russ case out of the 3rd DCA involved a special verdict by the jury. The jury specifically found on its verdict form that there was penetration. We don't have no such special verdict in this case. The 3rd DCA also said that there was no suggestion that mere contact was sufficient by the prosecutor. In this case, of course, there was. I just read to you what the prosecutor argued in closing. The Pinero case out of the 3rd DCA is also distinguishable. In that case, I'm quoting from the 3rd DCA, the state in its closing argument clearly explained to the jury that to prove that the defendant, that in order to prove its charge, the defendant had to have penetrated the vagina with his finger. So in that case, again, the prosecutor, even though the improper instruction was given by the judge, the prosecutor repeated the proper instruction and said, in order to prove this case, we must show penetration. Not here. In this case, the prosecutor relied upon both penetration and union in repeating the improper jury instruction. And also, just to note in Pinera, the 3rd DCA goes on to say that even though the judge gave an improper jury instruction, just before giving the improper jury instruction, the judge correctly told the jury that for the state to establish digital sexual battery, the state was required to prove, quote, penetration by an object. So again, the judge gave misleading instructions in that case. One was wrong, one was right. In this case, we only have incorrect instructions. And then finally, the Graves case by the 1st DCA. In that case, the 1st DCA said that the prosecutor focused only on evidence of penetration. And again, in this case, we do have the prosecutor mentioning the improper jury instruction during closing argument. So this is a fundamental error case. We have not only the judge giving the improper instruction, but also the prosecutor repeating it. There's sufficiently ambiguous testimony from the alleged victim as to whether or not it amounts to penetration or union. Certainly this court cannot say beyond a reasonable doubt that the jury wasn't misled or could not have convicted my client based only on the finding that my client had union between his finger and the alleged victim's vagina. So for all those reasons, I'd ask for this court to grant relief as to Claim 3, reverse the conviction for Count 1, consistent with this court's Lakey opinion. Let me switch gears to Claim 4, which concerns Count 6 of the alleged information. Count 6 involved a charge of lewd and lascivious molestation, and specifically that my client touched the bottom or the clothing covering the bottom of the alleged victim. The charge in the amended information said that this offense occurred between 2003 and 2011. The record establishes that the alleged victim was born in 1997, and therefore she turned 12 in 2009. Lewd and lascivious molestation is a life felony if the offense is committed against someone who's under the age of 12. It's a second-degree felony if the offense is committed against someone who is 12 or older. And as I just explained, the amended information in this case alleged a date span of 2003 to 2011, which means that part of that was when the alleged victim would have been under the age of 12, part of that would have been when the alleged victim was 12 or older.
But wasn't the jury instructed they had to determine that the victim was under 12?
They were.
So they made a finding to that effect?
They made a finding as charged in the information. And I submit that the information and the dates were read to the jury. I believe it's page 27 of the trial transcript at the beginning of the trial. So if an astute juror wrote down those dates or thought of those dates and then heard this instruction that or was told that you can find this person guilty if it occurred within that date span, and they checked the box as charged in the information.
They were advised if it occurred during this, and the victim was less than 12 years old, right?
That's what the instruction says.
Are you asking us to presume that the jury may have disregarded or disobeyed the jury instruction that was given to them?
I'm submitting to you that the jury was given inconsistent instructions. On the one hand, they were told that in order to return a guilty verdict for this particular count, they must find that the alleged victim was under the age of 12. I acknowledge that. On the other hand, they were told that this count included activity that occurred after the alleged victim turns 12, and the verdict form simply said as charged in the information. And the rule of lenity, if there's a doubt, the state should not have charged anything past the age of 12 if they wanted to get a life felony. And
let me ask you this. If the state alleged it the way they did, and then there was no evidence of any criminal act occurring after the child turned 12.
That's not true.
I know, but if there was, how would the problem been resolved? You would have had the same jury instruction given in this case, and you would have had the same argument made by the prosecutors done in this case. So why should there be a different result than...
If I understand your question, if you're saying if the only evidence in the case had been that the alleged victim was under the age of 12?
Right, and so the state either said or the defense moved for a directed verdict, and so, the judge agreed there was no evidence, so you're now in a situation where the state hadn't proven that part of the information alleging acts after the child turned 12. how would you proceed? Wouldn't you have proceeded the same way that happened here, and that is an argument by the prosecutor that, must be proven the child was under 12 and an instruction by the court?
I think my argument would be, I'd be in a worse position because the state could say there's no fundamental error here. The only evidence was that the alleged victim was under the age of 12, and therefore there's no possible way that the jury could have found that it was 12 or older. But in this case, and again, going back to the prosecutor's closing argument, and this is page 533. Now, count 6 is also lewd or lascivious molestation, but this count talks about the touching of the buttocks. Now, the alleged victim said, throughout 6 years old up until 13, he was still touching her butt. So the prosecutor in closing specifically tells the jury that they can find him guilty if it occurred anywhere from the age of 6 to 13. And a huge difference there, because 12 and 13, he's only guilty of a second-degree felony.
Well, I didn't hear from that excerpt that the prosecutor said that he could be found guilty even if it was over the age of 12. Didn't the prosecutor include the element of you have to show under 12?
The prosecutor repeated the instruction that the judge gave, and the instruction was correct. I'm not arguing
That
that...
excerpt that you read was not the prosecutor telling the jury that they could find him guilty even if the child was over 12.
Correct. I'm simply responding to the question. The evidence in this case clearly went across both date spans. So if even just one juror said, but the charges in this case went up until she was 13, and that's what is charged in the information, we can find him guilty if it goes up until the age of 13. And even if just one juror said that, under the rule of lenity, because the prosecution chose to choose these dates in the information, and they spanned whether it's a life felony or second-degree felony, my client should get the benefit of that doubt. Because there is no specific finding on this verdict form by the jury that this occurred while the alleged victim was under the age of 12. And it's possible that this jury could have been relying upon the allegations in the information, the dates in the information which were read to them, and said, I'm not sure if it happened when she was under 12, but I think in my mind it happened when she was 12 or 13. That's sufficient under this charge, and I'm going to find him guilty. And if that's the case, and because there's no specific finding by the jury, again, I acknowledge the instruction's correct, I'm simply arguing that they chose to charge time periods that span both a life felony and a second-degree felony. My client should get the benefit of that doubt. I see that I'm almost into my rebuttal time. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
May it please the court, counsel, Andrea Totten on behalf of the state of Florida. Beginning with issue 3, the jury instruction telling the jury that they could find defendant guilty by either penetration by the defendant's finger or union with. First, I would like to note that the information in this case, charged only penetration in the language of the information.
You concede there's an error in the state's brief in arguing that in the closing argument the prosecutor did not use both alternatives as a way to find a conviction in this case? Well,
Your Honor, I would concede that the prosecutor repeated the erroneous jury instruction in the course of her closing argument. However, she then went on to focus on the facts of penetration. She argued specifically, he now takes his hand and places it underneath her clothing. That increases from being underneath the clothing to inside the two lips. That's what she testified to, that he, Maxwell Leon, placed his finger inside of her vagina, violating her multiple times over the years frequently. So although it is true that the prosecutor repeated that erroneous jury instruction at one point, when she was actually arguing the facts of the case and why the jury should find the defendant guilty, she focused only on the testimony regarding penetration. And there was testimony from the victim regarding penetration. At page 200 of the trial record, the victim said, "In my vagina," at 204, between the lips. At 210, the prosecutor asked her again, did the defendant's hand or finger make it inside your vagina? You mean between the lips? Yes, yes.
Would you agree that the prosecutor never argue to the jury that the state was obligated to show penetration and that union would not be sufficient?
I would agree that she didn't say it in those specific terms, Your Honor, but again, when the
She argued, didn't she, in essence, argue that you had to show penetration or union by repeating the jury instruction, and then argued that the facts of the case showed penetration?
Well, I'm not sure that I would agree that she was arguing that the state could show union, or had to show union. I think she was just unthinkingly repeating the erroneous jury instruction. But again, her argument focused solely on the penetration, and I would argue that that is what she was telling the jury they needed to find in order to convict the defendant, and that is what she focused on in the questioning of the victim as well.
How would you distinguish the Lakey case?
In Lakey, Your Honor, the information specifically charged rubbing of the victim's vagina. In other words, union with. So right from the beginning in Lakey, the state had charged only union. That was the theory of the case. Rubbing, i.e. union, was what the facts brought forth. Whereas here, the information charged digital penetration. That was the theory of the state's case. That is what the prosecutor tried to elicit during her direct examination of the victim, and that is what the prosecutor argued in closing. For that reason, this case is more like Graves v. State, cited in my brief, where no fundamental error was found because the state did not try the case on a union theory, focusing only on the evidence of penetration. And also Pinero, cited in my brief, information charged digital penetration, and the prosecutor told the jury that penetration must be proven. Here, as you noted, Your Honor, again, the state didn't say those exact words to the jury, I must prove to you penetration, but she certainly focused her argument on the penetration and those facts proving that point, and never argued to the jury, as in Gill. And if you believe that only union occurred, contact between the hand and the anus, I think it was in Gill, then you can find the defendant guilty. Nothing of that manner happened in this case. Here, again, the prosecutor focused only on penetration. As to issue 4, the information did charge dates spanning from when the victim was under the age of 12 to when she was over the age of 12. The allegations in that particular count was that the defendant was touching the victim on her buttocks, both over or under her clothing. The testimony at trial was that this act started occurring when the victim was 6 years old and was something that happened in every encounter through to when she was 13 years old. But again, the jury was instructed by both the prosecutor and the judge explicitly, here's the elements of the crime. One of them being that we must have proven to you, and we did prove to you, that the victim was under 12. That was explicitly instructed to the jury by both the prosecutor and the court. So to reach the conclusion that the jury may have convicted him for acts occurring in that 1 year span between the time that she turned 12 and the time that she turned 13 and the abuse stopped, the jury would have had to have taken careful note of the dates in the information, went back and figured out on their own that there were some dates covered in the information when she was over 12, then completely disregarded the law as instructed to them by the judge and reiterated by the state. And we do not assume that the jury has completely ignored the law as instructed to them by the judge. There was lots of testimony from the victim regarding these acts occurring continuously from the time that she was 6 to 12. And again, the jury instruction was perfectly clear and correct on that count and was repeated to the jury again and again by the prosecutor and judge. So fundamental error cannot be demonstrated as to that issue. If your honors have no further questions, I will rely on my brief.
Thank you, counsel.
Thank you.
May it please the court. I'll focus my time on claim 3 and count 1. If the prosecutor had told the jury in closing argument that the only way that we can prove this count is if we establish penetration, then obviously my position would be much weaker. I would still argue that the evidence was sufficiently ambiguous, just like in Gill, but that's not what the prosecutor said here. The prosecutor repeated the improper instruction, clearly leaving the jury with the impression that union would be enough. And I submit that without, and I understand it's difficult in a case involving a minor victim. It may not be easy to use the terminology, the exact terminology with that minor victim to specifically say, now, as opposed to having union with, did he specifically have penetration in this case? But that type of testimony didn't come out. We are using language such as rubbing, feeling up on it, in between the lips. That's not that clear. It's sufficiently ambiguous. It's no different from the allegation of rubbing and Lakey, and therefore I submit the evidence was not clear-cut. It certainly could be interpreted either way by the jury, and so despite the fact that the prosecutor may have argued whatever was argued as far as the facts are concerned, when the prosecutor repeated the improper instruction to the jury was clearly left with the impression that all that's required in this case was penetration or union. And it cannot be said beyond a reasonable doubt that one or more of those jurors weren't misled by that and found my client guilty based solely on a conclusion that union occurred in this case. And for those reasons, consistent with Lakey, and because this case is clearly distinguishable from the cases that the state relies upon for all the reasons I've already stated, this court should reverse count 1. Thank you.
Counsel?